Let's get started here. Let me just welcome everyone to Chicago Kent's 2021 Constitution Day commemoration. The topic for today is going to be something of a cutting edge issue that a lot of people are interested in talking about, and that is the reform of the Supreme Court. I am so glad to have you here to talk about this topic. Before I get started, I am going to give just a brief overview to the other speaker. I want to say that Carolyn Shapiro, who is supposed to be joining us today, was unable to do so. She had a family emergency she needed to deal with. So today is going to be, I'll be running the show and with some help from my colleague, Nancy Martyr. My name is Christopher Schmidt. I'm a professor at Chicago Kent College of Law, where I also co-direct the Institute on the Supreme Court. Today, I'm joined by Nancy Martyr, also professor of law at Chicago Kent. Nancy's also the director of the Justice John Paul Stevens Jury Center and co-director of our Institute for Law and Humanities. And Nancy is an expert on Supreme Court, studying it from the outside and also having experience from the inside. She clerked for Justice John Paul Stevens. So with that, let me just give you an overview of how we're going to run the next hour or so. I'm going to start off by giving an overview of the topic, the question of court reform, why we're talking about court reform, what the issues are, what the different ideas for court reform are that are out there. So I'll just give some background. I have some PowerPoint slides to help guide us through that discussion. At that point, I'm going to turn it over to Professor Martyr to get some of her reactions to the issues, and she'll give a sort of step back assessment of what she sees as the key questions we should be thinking about and how we should be approaching this particular issue. She and I will then have a discussion, the two of us back and forth. I'll just ask her some questions and we'll push some ideas around. And at that point, we'd like to turn the program over to audience question and answer. So if you have any questions, you can signal that in several ways. You can put it up in the chat function. I believe you can use your raise hand feature, and I'll be keeping an eye on that. Or you can try and get my attention some other way. But basically, if you just want to get in the queue, then we can have a discussion. And that should bring us to about 1 o'clock today. So with that, let me put my slides up. And then again, I'll just be talking through the basic overview of the topic for the next 10 or 15 minutes. All right, so here is our topic for today, discussion of Supreme Court reform. Opening question you need to think about is, why would we even want to reform the Supreme Court? And this is a question that we're going to dive into in some depth today. And I know Professor Martyr wants to talk about this some. But for now, I want to assume that there are people out there who believe we should reform the court. And I want to think about what some of the arguments are for why we should reform the court. We're going to step back and think about how strong these arguments are. But I want to assume that there are some arguments out there and people do express a lot of concern and think that there should be some reform for the court. So let me just walk through some of the claims, some of the arguments that drive this current discussion that we should be reforming the court. The big argument is that the Supreme Court is somehow broken. There's something wrong with the court that needs to be fixed. And then there's a whole set of diagnoses of what exactly is wrong with the court. But the assumption is that there's something wrong that needs to be fixed. And then let's look at how these arguments break down. One way in which this argument goes is that the Supreme Court has become too powerful. All right, in a democracy, we should not have 9 unelected judges who have this much control over our lives. This is not a new argument. This is an argument that's as old as the Republic. You can actually go back to the very framing of the Constitution back in 1787. And people were making this very same argument. The court would be an institution that's too powerful. So this is nothing that's new. It's something that's always been with us. But it certainly is at the forefront of a lot of debates today about how strong this institution is, which is not a particularly democratic institution in terms of it's not a representative institution, and whether we truly can live in a democracy when we have an institution that's this powerful, that has this much control over our lives. So that's a concern about a too powerful court. We also have a lot of current focus on the court being too conservative. This, like the too powerful argument, is not necessarily a brand new argument. I think it's been given new life in recent years, recent decades. But concerns that the court is basically a conservative institution, in contrast to other institutions in our government, is also one that goes back certainly into the 19th century, beginning of the 19th century, even to the founding of the country. And the idea being that you have this powerful institution, which tends to be holding things back. When people are trying to push reform forward, law in general and the court as the apex institution of our legal system is a conservative institution, and there are people who are concerned about that. Of course, in recent years, we have a more powerful manifestation of this concern about being too conservative, but that also blends into concern about not just ideology, not just being a conservative institution in society, but also that it's a partisan institution. So today, when people are concerned about a court that's too conservative, they oftentimes frame it in a way that's not just too conservative, but it's also been basically captured by a single political party. And if you look at the current membership of the court, there are more members of the court that have been appointed by the Republican Party than the Democratic Party. So the idea that there's some sort of partisan leaning of the court, and that this is why the court is broken or dysfunctional, or perhaps why the court needs some sort of reform. So this is the Republican capture concern. We also have some concerns that the court's become too secretive, and maybe it's always been too secretive, but this is becoming more and more out of line in terms of modern society. And concerns of secrecy in the court oftentimes come into how the court's covered by the media. There's concerns about whether the court should have more transparency in how it runs its operation. This, of course, comes down to questions about cameras in the courtroom during oral argument, always a big topic that gets a lot of attention. There's questions about the court's process for accepting new cases, right? It has a certiorari process, which is basically how you get a case heard by the Supreme Court, and exactly how the Supreme Court decides what to take and what not to take is not particularly transparent. So there's concerns about this very important component of the court's work not being open enough. And then in recent years, there's been a lot of attention on what has become known as the shadow docket, this whole sort of part of the Supreme Court's work, which doesn't involve hearing, receiving briefs, hearing arguments, and writing fully drafted opinions. But it does show the exercise of Supreme Court power through its various orders it can make, which doesn't go through the more transparent process. The idea that there are a lot of things going on that are very consequential, but are not quite done and fully in the open on this shadow docket has been a key point of concern. All of these have been supportive of some people's arguments that there's something wrong with the court. And then finally, there's this big category of concern, which is that there's some legitimacy problem with the court. The court has lost or is losing or is about to lose its legitimacy. And this very much feeds into the above concerns, right? The court's too conservative, it's too partisan, too secretive. Then people say one of the consequences of that is that it's going to lose its legitimacy, that people no longer respect the court, no longer see it as legitimate, as a governing institution. And this, the argument goes, is particularly problematic for the court because the court doesn't have any inherent power, right? It doesn't have armies, it doesn't have the ability to tax. It pretty much only has the power of its persuasive abilities and the people's willingness to respect that. And if the court loses its legitimacy, then that's a serious concern. And then questions about, what are the causes of this loss of legitimacy? This, of course, goes back to the last 5-6 years of events around the court, which has caused a lot of concerns about the legitimacy. This goes back to President Obama's attempt to nominate Judge Garland to the Supreme Court, that was blocked and not allowed to go through, and then that was replaced with Justice Gorsuch. And then we have basically all the Trump appointments raising these concerns for a lot of people, with the process of Justice Kavanaugh's confirmation hearings caused a lot of controversy, people questioning whether the court can be a legitimate institution after such a fraught confirmation process. And then Justice Barrett's confirmation coming so closely to the last election, whether that was in fact a legitimate process. So a lot of concerns about legitimacy of the court. Some of it has to do with what the court is actually doing. Some of it has to do with the justice's own actions, but some of it, or much of it, is oftentimes traced back to the politics surrounding the court, and the idea that when these politics around the confirmation process become so politicized, so contentious, that this somehow is going to undermine the legitimacy of the court itself. So this is a claim. The claim is that the court is broken, the court needs repair, and the prescription for repair are going to be various reforms. I do want to just flag the question about, are these claims true, right? Is the court in fact broken? This is not a simple question to answer. It's a question in which one could approach in a somewhat of an objective manner, right? If you're concerned with legitimacy, people often look to public opinion polls. I will say the opinion polling on the court is it's a little bit you can see in it what you want. The overall faith in the court has fallen somewhat over the recent decades, but it hasn't fallen precipitously, and it's actually always pulled much higher than other comparable government institutions, such as the executive branch or the legislative branch. I think a recent poll came out which did indicate that over this past summer, it's taken something of a hit for a variety of reasons. But again, so it's declining. It's relatively robust compared to other institutions. Does that mean the court has lost its legitimacy, is losing its legitimacy? So there's objective ways in which we can look at the court. But it's also worth noting that a lot of this debate comes down to some more subjective judgment. Do people believe they're true? If, in fact, the court has been taken over by one political party or not, right? You can put that question aside and say, well, if people believe that is true, then that itself becomes a source of a problem. And that itself may create momentum or maybe even justification for reforms. So it is worth noting that many people do believe it to be true. It's also worth noting that there has been political momentum around court reform proposals. We can look back to the 2020 election when a number of Democratic presidential nominees were urging Supreme Court reform, were using Supreme Court reform as part of their platform. Pete Buttigieg, whose picture's up on the screen, was one of the people who pushed it most aggressively. President Biden didn't commit himself during the campaign, but once he was elected, he created a commission, which is still doing its work. So there is actually a presidential commission doing work right now, exploring the question about whether we need Supreme Court reform. You can look through the testimony of people who spoke to this commission. People spoke very passionately, saying indeed the court is broken and needs reform. And there's division of opinion on this, but some people did support that position. Lawmakers, including some Democratic members of the House, have pushed forth legislation to reform the court, including even expanding the number of justices on the court. The issue has become so prominent that some of the justices, most notably Justice Breyer, has recently spoken out against some of these court reform proposals, basically saying we should not be exploring or pushing in this direction. And he actually just came out with a book based on some lectures he gave last year, in which he defends the court and critiques these court reform proposals. So at this point, if we just assume that there is some interest, perhaps justified or not, but there is interest in reforming the court, let me just walk through the major reform proposals, and then I'll turn it over to Professor Martyr to look more closely at some of these questions I'm raising. So what's being discussed? The first option, the one that's probably the headline whenever we talk about the Supreme Court, is the idea of expanding the number of justices on the court. This is oftentimes referred to as court packing. And court packing is a term that goes back to the 1930s, when President Franklin Roosevelt, after winning a landslide election in 1936 and facing a Supreme Court that was standing in the way of some of his New Deal agenda, he actually floated a reform proposal and got this introduced into Congress, in which it would be a plan, a law that would expand the numbers of justices on the court. And he had a justification, which wasn't full, the real justification. But he said justification was the court's overworked, they're getting old, and therefore for every justice over a certain age, we're going to add a new justice, and that would have added some 5 justices to the court. His real reason was he didn't like the way the court was dealing with his legislative agenda, and most people actually knew that at the time. So there has been a past major debate in the 20th century about adding number of justices to the court. This court packing debate in 1936-37. It was defeated then. It did not get through Congress. And at the time, most people assumed that that was sort of the death knell of the idea of expanding the court for political or ideological purposes. But this idea has come back. And it has been a major point of debate over recent years, with more, I would say, this growing support for the idea of at least considering adding justice to the court. So court packing is sort of the big, most controversial, but also sort of the one that gets the most attention when we talk about reforms for the court. But there are a number of other reforms too that are out there, people are talking about. And then I just put a list of them up here. Some reforms look at the judicial powers. These are the concerns that the courts become too powerful, and they try to look for ways in which other branches of government, particularly Congress, might be able to limit the power of judicial review. Right? This could go from just Congress being more active, expressing their disagreement or views on judicial decisions. If they don't agree with a particular statutory interpretation of the court, then they could pass legislation responding to that, be more active doing that. Or maybe even more serious proposals, which would require likely constitutional amendment, in which Congress actually has maybe it's something like a legislative override. Congress can pass by a supermajority a law that could then override a contrary Supreme Court decision, something like that. Other batch of proposals fall within adjusting the voting requirements within the Supreme Court. Again, it's not quite clear how this could be achieved, whether it would require a constitutional amendment or not. There's some debate about this. But these proposals say things like, in order for Congress to strike down, in order for the Supreme Court to strike down an act of Congress, you need a supermajority in the court. So instead of just 5 votes, say you needed 6 or 7 votes for a court to make that particular action of striking down an act of Congress. Another related area of court reform is called jurisdiction stripping. Right, basically, Congress does have significant control over the kind of cases that the Supreme Court can hear. And then there's the argument some people have that Congress should use that power in order to take away certain cases from the court. Say the court can't hear certain categories of cases. Proposals for jurisdiction stripping have been around for a long time. They come up quite often. Generally, they haven't been pushed through. But again, it's a tool that Congress has that some people urge them to use more aggressively. A somewhat novel proposal that's come up during this recent debate over Supreme Court reform, or sometimes categorized as balanced court proposals. The idea here is that to overhaul the court so that it's not, you don't have a situation where the nominees to the court just happen to be based on the political commitments of the president who happens to be in office when there's an opening on the court, but you have something more sort of thought out in which you have members of the court who are identified with one particular party, other members are identified with the other party, and then you have a group who are supposed to be neutral, right? So these proposals, they're a little complicated about exactly how they work. There's one out there in which you have, say, 5 Republican justices, 5 Democratic justices, and then the remainder justices would be chosen by those 10 justices themselves, or you can have maybe a neutral selection body for putting justices on the court. And the idea is that somehow creating a court that doesn't have the problems of being seen as too conservative, too liberal, or doesn't have the problems of being captured by one political party or another. And they can actually try to self-consciously create a court that is designed to be neutral. Again, tricky to pull it off, but that's the gist behind some of these. Last 2 categories of proposal I'll talk about, term limits. So right now, Supreme Court justices are appointed for life. They can serve as long as they want, or as long as they're able to do so. Some people urge that to be reconsidered, right? The idea that justices should have long-term term limits, which allows them to not be particularly beholden to the party or the individual who put them on the court, but maybe those term limits should have some sort of an end point. Most assume that term limits of Supreme Court justices would require a constitutional amendment, which is one of the primary arguments against it, that it's just not feasible to make it happen. But there have been proposals put out, some trying to work around the constitutional amendment limitation. But the basic idea, the Supreme Court justices should have a long term, but a term that actually has an end point. And the idea here is that would give more regularity to the appointment process. You could plan it out so every president basically has 2 appointments per a 4-year term, and those appointments would come at regularly scheduled intervals, and then there would be less of happenstance around when these openings appear. And the last category of reforms I'm going to talk about are transparency reforms. These come in many different packages. They could be related to allowing more public oversight over what the court does, right? We can talk about cameras in the courtroom. We can talk about live streaming of audio. It is interesting to note that the court is back, and when it's back in session in October, will be in the courtroom with lawyers arguing before them, but without the public audience. These will be live streamed. The audio will be live streamed, which is a first for the court, at least while they're actually in their own building. So some people urge this as sort of an opening step where the court actually should allow more of it, at least as public events, for people to actually see what's going on, or at least hear what's going on in a live stream. Transparency reforms also include urging the court to give more justifications for why they take cases and don't take cases. Reforms to this concern with the shadow docket that I mentioned a little while ago. And also in this category, you can put ethics reforms. Currently, the Supreme Court largely polices its own ethics in terms of what they need to disclose and what they don't need to disclose. And there's some idea that Congress could give more requirements in terms of what kind of disclosures are asked for. For example, when Supreme Court justices do these trips around the world, who's paying for these trips and who are they speaking to? There's some people urging more transparency in that in terms of an ethics reform. So that is an overview of the issue, why people are talking about Supreme Court reform, and some of the main proposals for what these reforms might be. At this point, I'm going to pull down these slides and then allow Professor Martyr to give some of her reactions and thoughts about the topic of Supreme Court reform today.
Great. Thanks, Chris. Can you hear me okay? Yes. Okay, great. So I'm very glad to be able to be here today and to comment a little bit on the Supreme Court. And I just want to begin by saying I think the framework that Chris proposed is really helpful, that you need to look at what are the problems of the Supreme Court before you start talking about reforms. And so what is it that needs to be fixed? And I feel like a lot of the discussion of the reform does not take that into account. And then what is the evidence of that problem? And will the reforms, if you can establish some evidence, will the reforms address that problem? And who should address that problem? Which institutional actor? Because there are some reforms that the Supreme Court can address on its own, and others that seem to be calling for Congress. Also, I guess I want to encourage everybody to take the long view. And I believe Professor Schmidt does that as a legal historian. It's integral to his work. I tend to do that because I clerked for Justice Stevens. I clerked a long time ago, but I had the benefit of Justice Stevens. He had been a law clerk. He then was a justice for 34 years. And being able to see the big picture is really important. So even though I don't like the decisions that the Supreme Court reaches, and I would certainly prefer them to reach more progressive decisions, I don't really think that that's what the debate should be about, because you're talking about an institution over time, not what are the decisions it's making today. And I sort of see it as a pendulum swinging. Sometimes I'm going to like the decisions, and sometimes I'm not going to like them. But you're creating reforms that affect the institution over time. And so you really have to think carefully about those changes. I just wanted to mention two that came up when I was clerking. One was that Justice Souter was named to the Supreme Court. And at the time, he was named by President Bush, the first President Bush. And everybody thought that he would just be a copy of President Bush and embody his values. And that was not the case at all. So you have to think carefully about the justice, and the justice steps into the role. And we don't know, just because a justice is appointed by one party, one president from one party, that doesn't guarantee what kind of justice you're going to get. The other example I wanted to give was Planned Parenthood against Casey, which was when I was clerking, it was the case that was going to reverse Roe. And that was quite some time ago. And the three justices came together, surprising everyone on the court at the time, and took a more institutional approach, and one that valued stare decisis at the time. So I guess I'm just really arguing for the long view and not the quick or popular fix. But as Chris suggested, let's take these reforms and think about them, assess them. And so what if the problem is the court is too powerful? The justices are too powerful. And I guess the first question I want to ask is, what's changed to make them more powerful? Or are they using their power in some new way? And again, it's not enough to say just that I don't like the decisions they reach. I don't really think that's an answer. But let's say they are too powerful and we end up having some evidence of that. There are a number of reforms that have been proposed. such as not having the justices have quite so much discretion in the cases that they hear, or term limits. They shouldn't be all powerful for so long. They should be limited in the amount of time. I guess one before I go on to critique those, I would also want to ask, are there things the court can do on its own if the perception is it's too powerful? And I'm going to just give you a small suggestion, a little tweak. But right now, the justices rely on what's called the cert pool. So 8 of the 9 justices have a clerk from this pool recommend whether to grant or not to deny a petition. And that's a lot of responsibility resting on one clerk. And so going back to the traditional way, where each justice makes this decision for himself or herself, might sort of share the power and get more points of view. In terms of the term limits, which is one of the more popular suggestions being made to counter the power of the justices, I just want to point out what we lose if we went with term limits. You would lose, first of all, as Justice Stevens would say, you're learning on the job. It takes a while before a justice actually feels comfortable with the job, a number of years. And particularly it depends on what their background was, whether they were a state court judge or federal court judge. So you need to give justices a chance to grow into the position. And if they had a limited amount of time, you would lose the institutional memory that they bring, and you might lose the justice's best work. I realize, I use Justice Stevens as a model, and he's an unusual model, but I would argue that he did his best work from age 71 to 90. And he had his most important opinions, and they were far-reaching, and we shouldn't give those up. And I realize, not everyone is Justice Stevens, but we would lose that. In countries where there are term limits or mandatory age retirements for justices, when I've spoken to those justices, they've usually lamented the term limits. They feel like they had a lot more to contribute, that they were just getting to know their position really well and to feel comfortable with it. So I think we would lose that if we went with a reform like term limits. In terms of another common problem that could be the possibility here of what's motivating this discussion, as Chris said, there's the problem of, are the justices too secretive? Is the court too secretive? And there are certainly ways to make the court more transparent. I think that some of the suggestions, though, have unintended consequences, and that we shouldn't lose sight of the most important way to keep the court transparent. And that is that the justices write opinions, giving reasons for their decision. And I've heard some talk among some justices that maybe they shouldn't do that. Maybe it would make them seem less political or less polarized if they just had a court opinion, as you have in some countries. And so maybe they shouldn't dissent. Maybe they shouldn't concur. And I think that would be a great mistake. I think we gain a lot from hearing the justices' reasons and understanding that these opinions are not written in stone. I'm not a big fan of cameras in the courtroom, but I am happy with audio and hearing oral arguments on audio and even live stream audio. And one of the reasons is that I think that it keeps people focused on the argument and not on the entertainment of oral argument. And with cameras, you might focus on the gaffes, on the personal tics, instead of focusing on the argument itself. So I think that having audio is a good idea. And I think that the justices in this area control a lot of the change. So for example, recusals. The justices could provide more reasoning for their recusals. But I do want to point out that some of what goes on is that the justices do more informally speak to each other, even if they don't follow the federal statute that applies to the lower court judges. So some of these, this area of transparency is something that the court could act on in small incremental ways, giving reasons for its shadow docket or giving more explanation for recusals. And I guess I would say that the kinds of reforms that I think are more likely to take place are the ones that the court does itself, and also sort of small incremental steps, not ones that require constitutional amendments. So I realize this puts me in the minority. Most people want to talk about reform and big reform, but I guess from watching the court work and seeing its commitment to the institution, and I realize it can change over time, but there's a sense of wanting to make the institution function well, and that's something the justices know firsthand. So I'd rather see change come from the court rather than from Congress. With that, I will stop and we can take questions, Chris, from each other or from the audience.
So I do have a question or two, but before I do that, so on the chat, there's been a couple of questions about the cert pool. I'm going to steer your direction. So one participant asked, which justice doesn't use the cert pool? And someone else asked you to elaborate on what you mean by the cert pool and the impact of the proposed return of having justices make decisions directly, including the pros and cons of this. So we want to hear a little more about the cert pool, if you could do that.
Sure, I'm happy to talk about the cert pool. So currently, Justice Alito is the only justice who's not part of the cert pool. When I clerked, Justice Stevens was not part of the cert pool. And right before I started clerking, Justice Brennan retired. He also was not part of the cert pool. And Justice Brennan believed that it was the most important job that a justice did, which is to vote on cert petitions. So he would read the petitions as they came in. He'd read them himself. Justice Stevens used his law clerks to go through all of the thousands of cert petitions that came in. But then we could ask him to look at ones where we weren't sure, where we thought he should really look at it himself. So the way the cert pool works, right now, there's a cert pool, meaning the 8 justices share the bench memo from one law clerk, and each law clerk writes an extensive memo rather than something short if they had to cover many cert petitions. So it's a way of getting sort of in-depth information to the justices, but you're only getting one law clerk writing that lengthy memo. So that's sort of the trade-off. So when it originally began, the idea was to make the court more efficient. I guess efficiency was the priority there. The justices who suggested it didn't realize that it would become so prevalent that 8 justices would join the cert pool. So that's an example where you start out with efficiency, it ends up overtaking, and maybe now there's too much emphasis, too much power to one single law clerk.
So I just want to raise a couple of points that you brought out, which I thought were really useful, and then maybe just get one discussion point going, and then we can get the audience to offer up some questions as well. So one point I thought was a really important one to keep in mind, particularly when looking back over the course of history, is the unpredictability of individual justices, of the court as an institution. I mean, this is something that I think we all, when we think about ways of fixing institutions, you need to be somewhat hesitant being overly confident about this fix will produce this particular result. When I do think one of the lessons of history is that it's really hard to predict, particularly the core. I think because it's a relatively small institution, because it does work in ways that are somewhat different than the political branches of government, there is an unpredictability about the core, which I think all always should chasten us when being overly confident about our claims or what the court is or what it will do or what a particular change to the court would make. And then another point I thought was really important was that they focus on the perspective of the justices. The justices have, throughout history and certainly today, been very divided about really big questions of constitutional interpretation, about the role of the court, and all sorts of other questions. The justices, pretty much across history, and certainly today, have been utterly unified in their willingness to defend the court as an institution. I mentioned before that Justice Breyer had gotten some notice in the spring for speaking out in defense of the court and against court packing plans and court reform plans. I am sure that across the board, all 8 of his colleagues were either quietly or openly telling him, that's exactly right. We are with you on that question, right? We disagree with you on 9 other things, but on that thing about defending the court, we are with you. So it's sort of interesting to think about in the institution itself, you actually have a constituency that at the moment is quite unified, in which they stand up to defend the court and pretty much to push back most all reform proposals, which I think is different than other institutions that were reformed, because oftentimes you do have people within the institution saying, yes, there's something going on here that we need to fix. The court hasn't been that. And I do think if you want to just identify some obstacles to significant changes to the reform, it's going to have to be the justices. They are very effective spokespersons for their own institution. And going back to the most famous debate over court reform, which is back in 1937, when Roosevelt was threatening to pack the court, the justices lined up. Even the justices that were fully with Roosevelt in the New Deal, even those justices who really hated what those conservatives on the court were doing to the New Deal, they came out and said, no, FDR, you're wrong. And they did it, sometimes openly, sometimes more quietly. But they were quite united. So I think that's just one thing that if you're just sort of looking and trying to figure out what's going to happen, if ever you actually have members of the court who start in one way or another indicating that they are open to some sort of reform, that would be a huge change in the debate. And that really would be an opening to see if reform could actually happen. And then one last point I want to bring up. I agree with Professor Martyr that it's unlikely that any of these reforms are going to happen. But it is worth noting that the threat of reform to the court oftentimes can be powerful. It can have effects. And again, I mean, the big case study we have for this is 1937. The court packing plan failed, but the court packing plan did have an effect on the court, and that the court did change direction. And it's partly because of the court packing plan, partly because the court sort of run its course in terms of what it was doing. So some people who urge reforms are actually realistic about the fact that the reforms might not happen, but it could send signals. It could send messages to the court of the things that the people care about. So it is worth thinking about the reform proposals, not just on their merits, what the costs and benefits of them might be, but also in way, if people want to send signals to the court about what they're worried about, what they're concerned with, proposals for court reform actually are a pretty powerful vehicle for mobilizing around this and sort of amplifying some of these questions. And if ultimately, as Nancy indicated, the most likely reforms are likely to come from inside the court, if the court gets signals that, yes, this is something, we need to stop fighting cameras in the courtroom or live audio, these pushes for court reforms could be a way in which that message gets into the court a little bit more powerfully.
And I guess I would add to that the discussion that's taking place in the White House and through the commission, they don't seem to be looking at court proposals where the court is the agent of change. They're mainly looking at other ways of promoting change. And so that seems to be one institutional actor that's missing in this discussion. And the court, as you suggest, is very concerned about itself as an institution. And it is protective of the institution, and the justices themselves see themselves as judges, not as political actors. And I'm sure judges, like all other people, have worldviews and political leanings, but they view themselves as judges first and they step into this role. And while it's not played perfectly, they're trying to do it. And so they think they are doing it. They're not trying to be legislators. And so that's a distinction one has to make as well.
Great. So now we would love to get some audience questions or comments. You can do that in the chat function, or you can also put up your little electric hand using that Zoom function, and then you can jump in and talk to us. I do see one question up in the chat, and the question is there a world in which SCOTUS justices, and this is directly to me, is there a world in which SCOTUS justices abide by the idea of senior status, like appellate and district level judges? Perhaps a justice could take senior status to allow for a new appointment while working on a specialized cases as part of the court's docket. So I think this is a proposal which some people are using, some version of this, to push through term limits. And I will say, I think term limits would be a good idea. Sometimes when I think about court reform, is you can think about, we have what we have in front of us that has 200 plus years of history, and what would it mean to change that? And in that regard, you need to be careful about adjusting things that have settled in certain ways. But sometimes it's also worth thinking about, if we could just create a new Supreme Court right now, if we were just writing from a blank slate, what would we do? And I do think it's highly unlikely we do lifetime appointments to a modern Supreme Court. And if you go overseas, I know Nancy said some of these justices don't like the term limits, but most all modern constitutions have term limits for justices. So if you could just write from a blank slate, I do think term limits would be pretty highly likely to be part of that proposal. And also more than 9 justices could be likely too. Like, there's a lot of work to be done. So again, there's a difference between creating a brand new court in which you have 15 justices and actually doing the work it would take to pack the court to go from 9 to 15. So it's a different way of thinking about this. So the question here has to do with workarounds for term limits. The problem with term limits is you need a constitutional amendment. Constitutional amendments are incredibly hard to do. So can you have term limits short of constitutional amendment? One argument is that you could actually have new justices appointed to the court, but justices, when they reach a certain point in their tenure on the court, would not be pushed off the bench totally. They still have their lifetime appointment in line with the constitutional requirement, but they could assume some sort of senior status, in that they would still have that appointment, but then it would be understood that they would step down and do some other work, and new justices would come in. So you'd have basically de facto term limits in a way that didn't require a constitutional amendment. So that's the idea here. So this, I think, just comes down to the idea, but what do you think term limits are a good idea? And again, the arguments for term limits are the idea that you have more regularized appointments, right? So Nancy and I didn't talk a lot about the confirmation process, but when a lot of people think the Supreme Court is really messed up, the image they often have in their mind are the confirmation circuses, right? This clearly is not a good thing. So sometimes people look at Supreme Court reform as a way to try and fix the confirmation process. And one argument is, if you had lower stakes, so if justices were serving for, say, 18 years instead of 30 plus years, that would lower the stakes a little bit. And you have a more regularized process, then perhaps that could reduce the circusness of the Supreme Court appointments. So that's one of the arguments for why the term limits might be a good idea. And then thinking about ways in which you can get the term limits short of constitutional amendments. Sometimes you have this rotation idea, or this idea that people would assume some sort of senior status, which I think is an interesting idea.
So one question in the chat was how long a term limit should be. And I think, Chris, you can chime in, but I've seen like 15 to 18 years.
Yeah, that seems to be people who put some thought into this. The sweet spot in which you have a long enough term, because you don't want the term to be too short, because then the idea is a justice would feel some sort of connection or feel beholden to the person who appointed them or the party, and you actually want to have the insulation that a long term brings. There's also concerns about justices, like what do they do when they're done? Like right now, justices typically generally ride off into the sunset when they leave the court. If you have relatively short term limits, they would have long post-court careers, and there are concerns about what that would look like. But at the same time, the idea of term limits is, it's a little bit strange when you have people who were appointed like 30, 40 years ago by presidents who are completely come from a different world, still hanging out in the court making decisions that have a lot of consequences. So again, you don't want the term to be so long that you allow this disconnect that a lot of people feel concerned with. but it can't be so short that you risk the insulation at the long term. So again, most people have settled around 15 to 18. I think if around 18 is where you can figure it out that every president gets those 2 appointments. So every 4 years will be 2 appointments, and that would be regularized in a way that you could pull it off, I think, with 18-year terms.
I guess 2 limitations, though. One is that term limits really work only if you're, with each election, you're getting different parties winning. Otherwise, if you have a string of Republican elections, victories, then you're not getting the kind of variation you want on the court. The other area that we could borrow from is that term limits were very popular a number of years ago in state government. And governors have term limits, mayors have term limits, and there was a great popularity with term limits so that, you reduce the power of the incumbency. And then what happened, or what we learned in these other areas, is that you'd also lose expertise. And people would be thinking about, as Chris had mentioned, their next career, their next position. So we could look at what has happened to term limits in other areas of our government before we leap into term limits here. That's the caveat.
There's another very good question that came up in the chat. What evidence is there for the position that justices really see their role as that of a judges and not political actors, as opposed to merely presenting it as a veneer pretext? How can the number of 6-3 or 5-4 decisions almost perfectly aligned with political ideology be squared with the balls and strikes judging idea? It's a really good question. It's one I'm sure neither Nancy or I are going to be able to fully satisfy anyone on, because you're talking about what's in people's heart of hearts, and these people are very private and have all the reason in the world, not if indeed they had these thoughts, to divulge them publicly. I would just say, having spent a lot of time reading the justices' words and trying to get not just the words that they say when they stand in front of a bunch of law school students and talk about the court or give C-SPAN interviews or whatever. But if you go back in the history, you can find the words that they spoke in more private settings, how they spoke in letters. I will say, my perspective is that justices generally almost totally have been true believers in the idea that what they are doing is categorically different than what politicians are doing. Right. So if you're just trying to sort of figure out who they are deep down inside, we can only go so far, but we can try to sort of capture how they express themselves and how they talked about their roles. And really, I can't think of basically any justice who basically is willing to sort of self-conceptualize their role as fully reducible to nothing but advancing a particular ideology or a partisan commitment. Maybe if you go back enough in history to the 19th century, you can find people who are more straight up political actors, but at least not in the modern era. Now, that's different than saying, well, in fact, they're acting this way, and they could just say they're being self-delusional. Again, I'm just saying there's not evidence that, in fact, they're consciously portraying themselves one way, but truly believe something else. That's just hard to believe. It's just hard to find evidence for that. But then, it is worth pushing that aside and saying, but, how are their actions, what do they look like? Right. And then there's always a question of perceptions. What do people see them as? So I just would like to take those apart. I still stand by my characterization. I think the justice generally are true believers in a self-conception. And again, there's a lot of reason for why a justice doesn't want to just see themselves as a political actor hanging out in black robes, right? They've committed themselves to a life. They're part of an institution. And justices to a person value that institution incredibly highly. So I think there's reasons why they would really, truly see themselves that way, even though, as you indicate, there's lots of sort of external evidence for why that's a complicated characterization of what they do. But I know Nancy wants to put in this.
Yeah, I would also add that while we focus on the cases that are controversial and that seem like you could predict how the justice is going to vote, that's not most of the docket. I mean, I realize that those are the really big cases, but much of the docket, you can't always predict. You get unusual alliances. Justices end up on different sides than you would have imagined. And then, of course, a fair number of cases can be unanimous. So that's one response. But the other response I would give is that from working with a justice, and I realize that's only one justice, but from meeting all the other justices, you get a sense of how they respond to cases, the kinds of arguments they give, the kinds of reasons, the way they talk about briefs, the way they talk about earlier cases. These are not political arguments that they're making. We on the outside might focus just on the result, but the way they get to their result is, what we would consider appropriate for a judge to do. So part of it might be just the professionalization. They've been judges for a long time, usually in a lower court before they've gotten to the Supreme Court. They've been lawyers before that. Most of them are not politicians. I mean, there are exceptions, but they're not. And so they are approaching cases the way you would expect a judge to do. And so while I understand that there could be this false consciousness argument, that has not been the experience that I've had with judges, even if I disagree with the verdict they reach or the judgment they reach.
And just to chime in one more on this, this is not to deny that in those subset of very contentious cases in which social political issues are at the heart of the cases, that constitutional legal interpretation doesn't significantly overlap with ideology, right? I mean, we all know that Justice Gorsuch just looks at certain provisions of the Constitution fundamentally differently than Justice Sotomayor. And those differences of perspective there come down very much down to their life experiences and their ideologies and their commitments and their perceived alliances outside the court. Like, I don't think that's particularly controversial, right? Which is just different than saying how they understand the approach they're taking. And I will say, for advocates of court reform, this strikes me as cutting both ways. I think the way the justices work today is not all that different than the way they've worked in the past, right? There's a more polarized society and there's more divisions in society that predictably map onto the court. I think the way they see themselves as approaching their work is probably very similar to the way justices saw themselves approaching their work 10, 20, 30, 40, 50 years ago. So for advocates of court reform, they could just say the court's always been political, as in the political factors have infused their approaches to legal constitutional interpretation. And that's a justification of reform. For opponents of court reform, they can say, it's not falling off the rails, it's not broken, or it's not heading off in some dramatically different direction. There's been some skews because of the appointment process, but in terms of what the justices are actually doing, the argument goes that they're playing the same role that past generations of justices had, and therefore, if you didn't think the court should have been overhauled 50 years ago, there's no reason to think it should be overhauled today. Another question up in the comments, and again, feel free to put more questions in the comments or to put the Zoom hand up. This question is what was the impact of the last few decades of Senate dysfunction had on the court, making the court more powerful and creating more emphasis in court reform? So I think we could take this a couple of directions. One could be a more general dysfunction within the representative branches of government and how that creates more pressure on the court. So one argument is that as Congress generally does less because of the divisions of Washington, it makes it more dysfunctional, makes it able to do less, more issues fall on the court, right? When Congress is unable to get together to update statutes, there's more old statutes that the court needs to interpret, right? When Congress isn't acting forthrightly to deal with certain issues, that means a court may be urged or may feel the inclination to take up some of these issues. So this is just a general question, which gets back to, is the court too powerful? And is that power a product of other branches of government that are not actually doing what they should be doing? They're not serving the roles they historically have. The question also focused on the Senate too. So maybe this has to do more, or at least partly, with the confirmation process, right? So why has the confirmation process become so fraught? Basically become little mini political campaigns around a Supreme Court nomination. Some of that can be traced to divisions and the way the Senate operates, and that's different than it has been in the past. So that's another factor to keep in mind. Another question just came up. I'm troubled by the attention to the methodology by which justices are seen to make their decision. A political actor could use judicial methodology, but simply see everything through a political lens. and discount the arguments and evidence of political opponents. So I think the idea is, and Nancy, jump in if you have a different reading, the idea that by focusing on interpretation, you're avoiding actually engaging with the substance of the commitment that one is saying. So again, the idea is a conservative will say, I'm just an originalist, and this is simply an originalist reading of the Constitution, and therefore Justice Scalia need not embrace the fact that he has a very robust view of the right to bear arms. He can just say, this has nothing to do with my commitments. It all only has to do with my interpretive methodology. Yeah, I mean, this gets back to the same discussion about justice, how they see themselves and how we see what they're actually doing, right? That ideology, I think, certainly is moving. It is determinative in many of these cases, right? At the same time, they approach their ideological commitments through the lens of legal interpretation, right? And we can just dismiss that as nothing but false consciousness, as some sort of veneer. Or we could say that's how they approach it and then take it on its own terms. And taking it on its own terms is not to say, okay, we just need to talk about originalism, thumbs up or thumbs down, and not talk about what actually is being produced by these decisions. But it is worth noting that if you want to take the court on their own terms, these are the terms in which they are approaching it themselves. These are terms in which they're talking to each other about. So I do think if you just simply reduce it and say, no, that means that's it's just sort of window dressing. You're dismissing something that to justice, I believe they actually put value in, even if ultimately it's not dictating every single decision they have. So again, I think it comes down to audience. If the audience is the Supreme Court and trying to convey disagreement with the court, I think you need to take into account the seriousness of the ways in which they use methodologies, interpretation, and then attack the substantive decisions, but you keeping that in mind as you use that critique.
I guess I would add that their methodologies, I mean, the reason they try and develop these methodologies is they believe it's keeping them honest. I mean, we might disagree with any particular methodology, but they think it's a way of confining their role, sort of confining their interpretation. And so that's part of the discussion. They might not think their methodology has a lens, a sort of worldview lens. Some of us might think it does, but I think in general, talking about your methodology is a way of trying to constrain or limit the judicial role, and that's something that's supposed to be a good thing, sort of keeping the judge or justice from engaging in just a political calculation. So I don't, even if it's a methodology I don't agree with, I don't see that as one that's contrary to their role. With that, I'm going to have to say goodbye and tell you how much I enjoyed participating in this, but I'm afraid I must leave now.
Yes. Nancy needs to run off to another Zoom meeting. So thank you so much for joining us, but we are at our hour. So I can just thank everyone here for participating. Thanks. Thank you for all your great questions. Thank you for joining Chicago Kent's 2021 Constitution Day event. So that's it. Take care and have a great day.